Good morning. This is cause number 21-0321, Daniels versus Gallatin County and Atlantic Specialty Insurance. I'm going to assume that counsel are ready to proceed. I see both Mr. Habine and Ms. Sheehy on the Zoom. So Ms. Sheehy, I think it's your time to shine.
Actually, I think it's my time to shine, Your Honor. But
oh yeah, sorry.
Not wanting to steal any limelight from Martha.
Her name is above yours, so I just go ahead.
Good morning, Your Honors. My name is Peter Habine. I represent Atlantic Specialty Insurance Company, and I'll refer to Atlantic as ASIC this morning. May it please the court. This is a simple case of statutory construction. It turns on a single question of law. Under section 29108(3), did ASIC waive the benefit of Gallatin County's statutorily capped liability merely by issuing a policy to Gallatin County with a policy limit greater than the $750,000 per person statutory cap? The answer is equally simple. No. No, ASIC did not waive the benefit of the statutory cap merely by issuing a policy with a limit greater than the per person cap. This court's standard of review here is de novo because this case involves errors of law by the district court. Those errors originated with Daniels because Daniels wrote the order that the district court adopted verbatim without change. Montana Code Annotated 29108 performs two key functions in this case. First, it unambiguously caps the amount of damages Gallatin County can be obligated to pay to $750,000, an amount that ASIC paid long before this action was ever filed. Second, it provides that an insurer is not liable for excess damages unless the insurer specifically agrees by written endorsement to provide coverage for more damages than the county legally must pay. The statute could not be more clear. Gallatin County is immune from liability for damages above $750,000, period. And the county's insurer, ASIC, automatically benefits from that immunity unless it specifically waives the statute's protection by an agreement contained in a written endorsement. A review of the policy confirms that ASIC did not provide any such waiver, given that everyone, ASIC, the county, the district court, even the plaintiff, agrees that the policy contains no specific written waiver. In fact, it makes no reference to 29108 specifically or generally. And that's typical of liability insurance policies because 29108 is not a term of coverage or a term of the policy contract. It is instead a term of law. And the terms of law bearing on the county's liability are encompassed in the general insuring language of the policy, which reads, all sums an insured legally must pay as damages. That's the scope of coverage here. All sums the insured legally must pay. Yes, Your Honor.
It obviously begs the question then, why sell a $5 million policy?
Great question, and the answer is this. Because as this court ruled in in Delaney versus City of Bozeman, 29108 only caps a narrow subset of potential claims against Gallatin County. It only caps those claims that fall within the definition of claim in 29101. And it leaves uncapped huge categories of potential exposure that Gallatin County faces here. And I can go into those kinds of exposures right now if it would be helpful to the court.
Well, counsel, following up on the chief's, I'm sorry, chief, you want to
No, go ahead.
go? Well, just following up on that, I mean, the 1.5 million was specifically an auto claim.
Correct.
So, I mean, how does that coincide with what you're saying? I mean, that would be a claim that would otherwise be covered by the damage cap, wouldn't it?
An auto claim here is covered by the damage cap, but there are a whole categories of claims that would be subject to potential, subject the county to potential liability.
Well, no, but I'm sorry, but let me just interrupt you for 1 second. I get that, but that's to the point that why, if ASIC wasn't waiving these claims, Gallatin County purchased an auto claim, and they purchased an auto claim for an amount above double what the statutory cap would be. And that would be something that, as you said, if it would have been covered by the cap, then isn't the extra $750,000 basically they're paying a premium for illusory coverage? Well,
no and no. and if I can explain, Your Honor.
Yes.
So what sort of caps, what sort of claims fall outside the cap's protection here? And I'm going to address myself specifically to auto claims that fall outside of the cap's protection, all right? Because I think that's what the court's question goes to. And the county's witnesses here provided undisputed testimony about the kinds of claims they expected to be covered that fell outside the caps. Those were federal claims, civil rights claims, 1983 claims, claims arising outside the state of Montana that could expose the county to uncapped damages. And the potential for those claims is substantial. The city of Minneapolis reportedly settled George Floyd's 1983 claim for $27 million. Now the court, Your Honor, Justice Shea might ask, what does that have to do with an auto claim? The answer is that it has everything to do with an auto claim. George Floyd was being put into a patrol car and then taken out of a patrol car and then pinned against the right rear tire of the patrol car when he was killed. Those actions, this court has already held, constitute the operation, maintenance, and use of a motor vehicle. The court reached that holding in Wendell versus State Farm. This is a case in which a passenger in a car was pulled out of a car and beaten to within an inch of his life in a parking lot. And this court held that that had to do with the operation, use, and maintenance of a motor vehicle and was covered under that motor vehicle policy insurance. So a 1983 claim here could subject the county to enormous uncapped damages. The US Supreme Court said in Owen versus City of Independence, Missouri, the following: by its terms, Section 1983 creates a species of tort liability that on its face admits no immunities. Its language is absolute, unqualified, and no mention of any privilege or immunities or defenses that may be asserted. So that's the kind of uncapped liability the county faces on an auto claim.
Mr. Habeen,
Yes.
Excuse me, we're not here on a 1983 claim, and I understand the questions that are being generated, but we are here, or let me ask you, if the policy had specifically referenced 29108, we would not be here today, is that correct?
Your Honor, we would be here today, and we could be here on any number of particular questions. It is clear, I would suggest to the court, it is clear from the statute that there is no requirement that the policy reference 29108. In the same way, Your Honor, that the policy doesn't reference other laws that bear on the county's potential liability. For example, the contributory negligence. The county's liability in this accident, if there was contributory negligence by Sarah Daniels, that contributory negligence would bear on the county's liability. It would limit the county's liability to the extent of the contributory negligence. But contributory negligence is not mentioned in the policy at all, nor is the American rule on recovery of attorney's fees, for example. All of these things are laws that bear on the county's liability, but they're not in the policy, named in the policy. Instead, they are encompassed in the phrase, all sums the insured legally must pay.
Mr. Habine, the policy does have endorsements that specifically reference Montana changes, including conformity with statutes, and doesn't say anything about the caps in any of those statutory endorsements. So does that square, I guess, with your argument? Is that part of your argument that it doesn't have to, even though it specifically mentions other statutory? I mean, it says any provision of the policy that does not conform to the minimum requirements of a Montana statute is amended to conform to such statute. So it does seem a little less specific than it could be here.
Your Honor, in answer to your original question, does it conform to our argument? Absolutely it does. It supports our argument and makes the very point here that 291083 requires something very specific from the insurer. The insurer is automatically protected from any exposure here above the caps, automatically by 291083, unless the insurer decides to opt out of that protection. And how does the insurer opt out of that protection? By a specific written agreement contained in an endorsement evidencing the insurer's intent not to be protected by the statutory caps here.
Mr. Habine, section 103 or 108 sub 3 is one sentence, and it talks about that the insurer is not liable for the excess damages unless the insurer specifically agrees by written endorsement to provide coverage in excess of the limitation, and then says, comma, in which case, I'm inserting some verbal ellipses here, comma, in which case the insurer may not claim the benefits of the limitation specifically waived. How, I mean, it doesn't, a plain reading of that is that the writing the policy for in excess of the limits constitutes the specific waiver, doesn't it?
No,
I mean,
no.
It doesn't, where in that subsection does it say anything other than the writing of the endorsement in excess of the limit is the specific waiver refers back to the first part of the sentence. I mean, it's just, how can we construct that sentence any other way?
Let me see if I can help, Your Honor. Your Honor quoted the section correctly. An insurer is not liable for excess damages unless. Now, let me, if it's all right, this will take a couple of minutes. Bear with me, and I appreciate the court's patience. The main clause of that sentence is an insurer is not liable for excess damages unless begins the subordinate clause grammatically, right? So the first question is, what insurer is not liable for excess damages? And the answer is certainly not an insurer that only wrote limits equal to or less than the statutory caps, because that insurer's limits would never allow the insurer to ever be liable for excess damages. So the only insurer that this subsection addresses is an insurer that wrote limits greater than the caps. That's the only insurer that this applies to. In other words, it applies to ASIC. And so what it's saying is an insurer that wrote limits greater than the caps is not liable for excess damages unless, and the unless is what's important here, unless the insurer specifically agrees by written endorsement to provide coverage to the governmental entity in amounts in excess. The statute makes a distinction between coverage and limits. Limits, remember, are not coverage. Limits are only relevant in this policy and only apply to amounts the county is legally required to pay. Let me say that again. The limits only apply under the insuring clause of the policy to amounts the county legally must pay. So the coverage here is amounts the county legally must pay. And 29108(3) specifically makes that distinction between coverage and limits. And it's the coverage that must be amended here, namely the insuring clause of the policy. Now you might well ask, well, how does the insurer do that? Do we have an example of an agreement that does exactly what this statute suggests is required? And the answer to that question is absolutely, we do. We have a statute that gives us exactly what we need in a template for what that agreement would look like. And it comes out of the statutory history here. When 29108 was passed by the legislature repealed a number of prior statutes, including 3323-101. And this is cited and quoted on page 26 of our brief, Your Honor. 3323-101 was on the books for more than 20 years, and it provided the following, and I'm quoting: waiver of defense of sovereign immunity required. All contracts or policies of casualty insurance covering state-owned properties or state risks must contain an agreement on the part of the insurer waiving all right to raise the defense of immunity from suit. No money may be paid as a premium on any such policy or contract of casualty insurance unless the policy or contract contains such an agreement. That is the statute. In other words, for more than 20 years, the state required insurers to attach a written agreement to their policies, waiving the benefits of statutory immunity. And so when this statute was repealed, when 29108 was passed, the state had more than 20 years of policies on the shelf with this written agreement attached to them.
So, Mr. Habib, can you, and if I've interrupted your train of thought, I apologize. But I'm sure that Ms. Sheehy is going to raise this, but can you address the idea or the requirement in the insurance code that the policy contain all terms and agreements between the parties? And how do we get around that based on, and I'll also see your argument as being one of pure statutory interpretation, whereas Ms. Sheehy's argument will be inflecting the policy and contract law into it. And I kind of think that that's the crux of the issue here is how do we combine or so that, I'm sorry, that's questions, but.
Well, yes, and I can answer that question, Your Honor. If I understand what Your Honor is driving at, the general requirement that the policy be in writing and that it contain the agreement of the parties is absolutely true and absolutely supports our view of this case. This policy is complete. It contains the entire agreement of the parties. That agreement consists of a general insuring clause that says the company will pay all sums the county legally must pay as damages. That's the general insuring clause. That
Right, well, then I would add to that, can you address the idea that has been put forth that the county is legally obligated to pay the $12 million judgment plus that Judge McLeay found?
Apologize, Your Honor. Yes, absolutely. The judgment here, Your Honor, is, in our view, completely irrelevant. And I'll explain what I mean by that. The state of play at the time the judgment was entered, at the time the trial occurred, the state of play was this. Daniels had filed an amended complaint. And in that amended complaint, as a core allegation, Daniels alleged that 29108 protected the county against any liability above $750,000. That was undisputed, number one. Number two, the state of play was that ASIC had, long before the action was filed, paid $750,000 here, number two. Number three, the state of play was that the district court, before trial, dismissed Daniels' constitutional challenge to the statute and dismissed it based on the representations by Daniels that under no circumstances would they ever seek to recover anything from Gallatin County because $750,000 had already been paid. So against that backdrop of no jeopardy to the county and admitted application of the statute protecting the county, dismissal of Daniels' constitutional challenge, the trial takes place and the judgment is entered. At that stage,
Let me interrupt
there
you for
is
just
no
a
legal
second.
jeopardy. Sorry.
Because my recollection, and correct me if I'm wrong, is that the agreement not to enforce and not to challenge the constitutionality didn't happen until after the appeals had been filed. And at the time the district court dismissed that claim, it was because the district court had ruled that the statutory construction controlled. And so that other claim didn't need to be considered. But at that point, I didn't think that Daniels had waived those other arguments. Am I wrong on that?
I think you are incorrect, Your Honor. And if I could just correct it slightly, and that is to say that count three was in the amended complaint was the constitutional challenge. In their briefing and moving papers on count two, the declaratory judgment count, Daniels repeatedly told the court that under no circumstances would it ever seek to recover any amount of money from Gallatin County. Those representations are quoted in our brief, cited there, Your Honor, and they appeared in multiple places in the moving papers by Daniels. So the court then proceeds to the summary judgment motion on count three, the constitutional challenge, and issues an order saying, based on Daniels' representations, I'm dismissing this count. And so the constitutional challenge is dismissed. The validity and effectiveness of the statute protecting Gallatin County is absolutely undisputed here. It is, as I said, a core allegation of Daniels' own amended complaint. So my point is that at no time has Gallatin County ever been in any legal jeopardy here. And it's true, Your Honor, that that subsequent to the filing of the appeal, Gallatin County has dismissed its appeal, and the plaintiffs have, Daniels has entered into a covenant not to execute, and has in addition dismissed its cross appeal on the constitutional challenge. So that leaves us right back at the same state of play we were in the district court. There is no legal jeopardy to the county whatsoever. There is no circumstance under which the county will ever pay one penny here. because ASIC has already paid the entire full capped exposure of the county.
And counsel, on that point, this is Jim Rice appearing as Kevin Cook today. That point takes you back to your exegesis of the statute, your interpretation of it, that you were about ready to finish. And let me ask you a question about that. Would you agree then that the plaintiff's waiver argument that the insurer has waived the $750,000 cap also requires that the insurer waived the terms and conditions of coverage under the policy, that in order to get to not only the payment of a greater amount than the limits, you have to waive not only the limit amounts, but in this case, you have to waive the underlying terms and conditions of the policy that provide the coverage. Specifically, the term and condition that we only pay what you insured are obligated to pay.
That's exactly right, Your Honor. And again, this is so fundamental because the whole purpose of liability insurance is to pay what the insured legally must pay. That's the purpose of liability insurance, not to pay more than the insured legally must pay. And most insureds would find that a breach of the insurance contract if the insurance company did pay more, because they're saddled with the loss experience of that excess payment that's going to follow them in the marketplace every time they try to find insurance. The whole point here.
Oh, but Mr. Havine,
Mr. Hobbit,
I'm
go
sorry,
ahead.
Go ahead, Justice. I was just going to say, I mean, isn't that specifically what 108 sub 3 specifically contemplates, is paying more than what the limitation is?
Yes, Your Honor. If that, and that's why the terms of 108.3 are so critical. That's why it has to be in writing. It has to be an agreement. It has to be an endorsement attached to the policy. It has to specifically waive the benefits of 29108. Specifically, Black's Law Dictionary defines specifically as naming a particular thing or place. That's why there has to be some endorsement that specifically waives that, like the one I just quoted from 3323-101.
So, Mr. Hobbine, I have two questions for you. I mean, and I don't have the site of the one case, I'm sorry, but how do you address, there is a case that says we go ahead and we let the court determine what the total damages are, right? So that we have a way to determine what the legal liability is. And those damages are the legal liability. And then you go and apply a limitation on it after determining the legal liability. I wish I had the case right before me. I thought I had it in my notes, but I don't. And my second question is, doesn't ASIC do the very thing you're saying it does in 13 other states by adding a specific provision in the policy? Like, they know how to do this, but they didn't do it here. So maybe you can address both of those.
But I'm going to try to keep them straight, Your Honor.
Okay.
So your last question is the one that's fresh in my mind, and I might have to come back to you for the first question. But so the last question is what I want to address first, and that is the first question that I would pose is, does the statute in Montana require the insurance company to do something here? And the answer is no. I mean, I think that's undisputed. The insurer is not liable for excess damages unless it does something specific to make itself liable.
Right,
So,
like having a policy in excess of the coverage and then charging a premium for it.
that's not enough, Your Honor. And
Okay.
and that's clearly not enough under the statute. charging a premium for the coverage here launches me into another response, and that is that it is absolutely undisputed here, Your Honor, that there is no illusory coverage. The testimony of Joe Caulfield, of Frank Rios, the underwriters here, the document production absolutely establishes that the company's underwriting and premium setting software takes into account the full effectiveness of Montana caps and calculated the premium for Gallatin County based on those caps. And so the actuarial evidence is completely undisputed here. There is no allegation at all that Gallatin County paid for something it didn't get. On the contrary, it paid for everything it applied for, and it got everything it applied for. And but second, and let me go back to your last question, which was, couldn't the company have issued some sort of an endorsement here? And my first response was, well, the statute clearly doesn't require it. That's true. And so you're already in the realm of, well, what if you did something that was not required by law? What if you did that? And I would suggest that you are into the realm then of unintended consequences. That is to say, if we were to have issued a non-waiver endorsement in Montana, right, saying we don't waive the caps here, well, what would that non-waiver endorsement engender? It would engender an argument from the plaintiffs that in the absence of that non-waiver endorsement, there must have been a waiver. And so now you have a circumstance before the court where the argument is you waived, and then the non-waiver endorsement tries to unwaive. And so what do you have then? And as I say, now you have the rule of unintended consequences. But the final response here is in the plaintiff's handouts that were delivered to the court yesterday, the plaintiffs have cited to the Kansas statute. The Kansas statute and to an endorsement that ASIC uses in Kansas. The Kansas statute is dramatically different from this state's statute. In fact, the Kansas statute is this state statute that was repealed by 29108. It's a simple limits waiver statute, in which case the insurer issuing a policy in Kansas waives the caps to the extent of its limits, period, right? And so in Kansas, ASIC is required to issue a drop-down endorsement that says that in any claims covered by the cap, its policies drop down, the limits of the policy drops down to the cap. That's required in Kansas. It's not required here. And it's a good thing that it's not required here, Your Honor, because this court has already struck down drop-down endorsements on policies in 2 different cases. It's already struck down in Lebrand versus National Union and in Cole versus Truck Insurance Exchange, I believe are the 2 cases. This court has struck down the very endorsement that ASIC is required to use in Kansas.
So can there be waiver by course of conduct?
No, Your Honor. The statute is quite clear that the only way to waive here is to do it by a written endorsement. And that gets back to to your first question. And that is, obviously the policy must contain the entire agreement of the parties, right? And pursuant to that question, there can be no waiver unless it's contained in the written terms of the policy, right? So now your first question, Your Honor, which was related to, I'm sorry, a case that.
Well, I'm sorry, I just don't have the case right at my fingertips. I'm going to guess that Ms. Sheehy will be able
it's
to.
that Mackin case.
It might be that we said that you basically let these go to a full verdict, and so that you determine what the damages the insurer is legally or insured is legally required to pay, and that the statutory cap really doesn't come in and
No.
really doesn't determine the legal obligation of the county with regard to damages.
So I think Justice Baker is correct. I think that's the Mackin decision. Mackin occurred construing the statute that was repealed by 29108. And that statute had a very unique requirement in it, or opportunity, let's say. It had a provision that said that the county could not be liable above a certain amount. But if the claimant wanted to petition the county to waive its potential immunity up to a certain amount, it could do that. And in its sole discretion, the county could waive its immunity in order to compensate that claimant. It was a specific procedure requiring a petition by the claimant. And so the court said, well, naturally, you have to have a trial so that you can determine what the actual damages are, the facts, right? The law is not in dispute here. The law was never in dispute in Mackin. The county could not be liable above the cap unless it decided in its sole discretion to make itself liable and to compensate the claimant. It was a unique, as I say, a unique procedure in the statute that was triggered in Mackin. And the court there said, well, you have to have the trial simply to provide the fact of the actual damages. It's clear the county's not going to be liable for them, but in a subsequent petition, those actual damages might be relevant. That whole process is gone. It was repealed by 29108 and simply isn't relevant any longer. The only circumstance that I can think, and Your Honor, it just triggered a thought in my mind here. The only circumstance that I could think where the trial could have taken place in this case is if, for some reason, ASIC had determined that this case was not worth $750,000 and had instead refused to settle for the statutory cap amount and had forced the plaintiff to trial to prove her damages. In that circumstance, an excess verdict would raise, as this court knows, raises additional questions related to the insurer's reasonableness and the way it responded to the settlement demand or the reasonableness in going to trial. All of those kinds of extra contractual conduct of the insurer issues could arise in that circumstance, but that circumstance is not this case. This case, ASIC paid $750,000 immediately, long before the action was ever filed. So that simply isn't the circumstance. I don't know where I am with time, Your Honor.
Mr. Rabin, if I could ask one question to follow up on Justice Gustafson. I think she named a number of states where ASIC has had that, and why wasn't it done here?
And the answer is simple, Your Honor, because in those states, the statutory scheme is very different from Montana and simply requires the insurer to do something different in order to either opt in or opt out of the statutory cap protections. So this is a circumstance where you have an insurance company, Atlantic Specialty, who is very careful in reviewing the state laws, in making sure that it complies with the state laws, that it does what is necessary in every individual state. And as you know, every individual state's insurance laws are different on these issues. So you know, I'm trying to save the trouble of going through every particular state and explaining why that law is different from Montana's. But here, Montana's law is quite clear. It requires the insurer to do nothing. The insurer is automatically protected under the caps in 291083 when it
Mr.
issues a
Hubine.
policy in excess of the caps.
Mr. Hubine, you've exceeded your time limit.
Thank you, Your Honor, and I appreciate the opportunity.
Thank you.
May it please the court. Martha Sheehy here on behalf of Sarah Daniels and Sarah's conservator, Don Daniels. With me in my Zoom room are Travis Kinsler and Jonathan Koch, also representing the Daniels family. Justice McKinnon correctly anticipated that I will argue that this court need not really consider Section 29108, but given the questioning and the argument made by Mr. Hobine, I'm going to address the statute first, and then get back to the interpretation of the policy. The statute 291083 must be interpreted according to the plain terms. The hallmark of statutory construction is to affect the intent of the legislature. So first we look to the terms of the statute. As pointed out by Justice Shea, this statute reads pretty plainly with only the names of the parties inserted. 291083 states, ASIC is not liable for excess damages unless ASIC specifically agrees by written endorsement to provide coverage to Gallatin County in amounts in excess of a limitation stated in this section, in which case ASIC may not claim the benefits of the limitation specifically waived. This is a single sentence divided into two parts. The first describing an action on the part of the insurer, and the second defining the result of that action. The language of the statute clearly establishes a cause and effect, with the use of the term unless to describe the action, and in which case to describe the results of that action. Moreover, the statute uses the word specifically twice, indicating that it's modifying the same thing. When an insurer specifically agrees to provide coverage in excess of the caps, then the caps are specifically waived. The statute is plain. However, the second rule of statutory construction is that you must interpret this statute in a manner that is consistent with the entire statutory scheme. ASIC has thrown out all of Title II, Section 9 in coming up with its interpretation of this statute. ASIC's argument is based on an unsubstantiated and completely incorrect assertion as to the intent of Section 291081 or 3. On page 18 of the opening brief, ASIC asserts that the purpose of the statute is to, quote, guarantee that an insurer is insulated from damages exceeding the 291081 liability limit unless the insurer specifically agrees by written endorsement to waive that protection, unquote. Not only is this intent to protect insurers not evident anywhere in 291083, the legislature clearly did not intend to guarantee that insurers would be insulated by the caps. And this is seen by looking at Chapter 9 in Title II as a whole, as this court did in great detail in the Crowell case. Crowell was subsequently overruled by 29111 amendments, but this court in Koch went back and said, this is an excellent summary of Title II, Chapter 9. So it's in fact, this court said that the summary in Crowell should not be overlooked. So let's not overlook it today. In Crowell, this court looked at Title II, Section 9, and it specifically pointed out that Section 29108 had been in existence for a long time and contains an excess damage exception. This court also looked at Section 29211. 29211, according to this court, provides all political subdivisions of the state may procure insurance separately or jointly with other subdivisions and may elect to use the deductible or self-insurance plan wholly or in part. In substance, this section grants to, in this case, school districts, an unlimited authority to purchase such insurance as the school district decides to be appropriate, both in terms of coverage and amount, and to insure by means of either regular insurance or some form of self-insurance. It's very important to look at 29211 because that statute authorizes political subdivisions to purchase excess coverage. The term excess coverage in 29211 then relates back to 29108.3. Here, Gallatin County used the discretion provided by 29211 to procure coverage for auto liability in the amount of the cap, and then to supplement that coverage with excess coverage, exactly as allowed and authorized by 29211. Gallatin County determined that it was appropriate to pay $628,000 a year to obtain coverage in excess of 6.5 million. As this court emphasized in Crowell, the grant of discretion to purchase excess insurance is not limited by statute. So looking at 29108, in light of this statutory scheme, we know that the legislature specifically intended to allow political subdivisions such as the county to purchase excess insurance. Note that the other two methods of protecting liability are by entering into self-pooled pooled arrangements with other counties or self-insurance. So those are the three methods that you can protect a county according to 29211 and other political subdivisions. In this case, looking back now at 29108, notice that 29108.1 caps only the liability or the recovery from the liability of the county. There is no mention in 29108.1 of insurers. It only caps counties from recovery against their liability. Contrast that to 29108.3. 29108.3 only addresses insurers. It doesn't address the other two types of ways of protecting. It doesn't address self-insurance by counties or pooled insurance. This is a specific directive to insurers. When a political subdivision opts to buy insurance and even to purchase excess insurance as allowed by 29211, then you are confronted by the limitations of 29108.3. Another important consideration when looking at the different ways of protecting the county is that if an insurer, or I'm sorry, if a political subdivision chooses to self-insure or pool insurance, then the coffers are affected, the public coffers are affected at the time liability is imposed, because that self-insurance fund must be paid out of what is essentially the public coffers. This is not the same arrangement with insurers. Knowing that Title II, Chapter 9 is intended to protect the public coffers, look at what happens when an insurer grants coverage to a political subdivision. The political subdivision decides we're going to purchase insurance. That's how we're going to cap our risk. And they enter into a bargain, which the premium is the thing that affects the public coffer. So the premium and the benefit of that bargain paid with the public coffers must be protected. It's protected by 29108.3 because 29108.3 says that by providing excess coverage, then the insurer may not claim the benefit of the cap. It's also important to look at that language, may not claim the benefit of the cap. It's not waiving the cap on behalf of the county. It's not doing any of those things. It's simply saying that in these circumstances, and under 211, a political subdivision is authorized to buy excess insurance, and when it does so, the caps cannot be relied upon by the governmental entity or by the insurer. That conclusion is buttressed by the fact that or that the insurance code and Title II are in a way cross-referenced. Because when drafting 29211, which authorizes protection by either pooled insurance, self-insurance, or insurance, the legislature also went into the insurance code and specifically exempted pooled insurance and self-insurance from the insurance code. The legislature did not exempt from the insurance code's mandates insurers, private insurers who provide excess coverage to governmental entities. So the insurance code clearly applies to ASIC, which brings us back to the intent of the legislature being to protect the public coffers, not an insurer, because the insurer reaches the agreement as to what is covered at the time of the premium. And when the premium is paid, it is the insurer's obligation to have a policy which specifically defines that risk that is covered. And that is the problem here. I'd
So,
also
Miss,
oh, go ahead.
seems to me you're about to jump to the policy, so I would appreciate if you'd address the argument that there's no illusory coverage here and that the coverage is actuarially, the premium is actuarially sound in terms of the cap.
We raised below that there was illusory coverage, that providing excess coverage that can never be triggered is illusory. However, the court didn't rule on that basis. There is a dispute as to what they paid for, and the dispute can only be resolved in favor of finding that the intent of this policy was priced to provide coverage for 6.5 million in all claims. The ASIC, let me find my note on that. ASIC early on filed an affidavit saying the price that they paid for this coverage, which was high, $628,000 a year to get a $750,000 limit, that's not a good deal. But ASIC was claiming that the price that was paid really included only coverage in excess for otherwise capped claims. They filed an affidavit from Joe Caulfield, whose name you've heard reported here today. And Joe Caulfield testified by affidavit that the insurance premiums would have been quote unquote much higher. We deposed Mr. Caulfield. And Mr. Caulfield's testimony didn't support that assertion. When noticed up for a 30B6 deposition for the purpose of determining what was paid for in this policy, he could only identify a $7,000 price difference. Also important about that dispute is that it is clear that ASIC didn't run this policy two ways at the time of contracting. ASIC didn't say, here's how we can cover all these claims, and here's how we can cover these claims by excluding anything that would otherwise be capped. So after the fact, when asked to define what would have been much higher means, Joe Caulfield was able to identify only a $7,000 difference in premium in a $628,000 premium policy. There is nothing in this record that indicates that these parties to the contract ever negotiated on the terms of we are specifically trying to cover only otherwise capped claims. There were no discussions about the $750,000 limit. There were no discussions about 29108. Mr. Caulfield testified that they wrote this policy based only on the application. We've provided that application to you in handout 4. I'm not going to go through it on the screen, but there is no mention in that application. And when you look at the actions that were taken during this term of this policy, every single action taken by ASIC is inconsistent with the finding that ASIC intended to cover only these claims that happen in the federal system, or these identified claims that they identified, of course, after the fact. At the time of contracting, they never discussed any of these things. ASIC's application, its own form, that you can see at handout 4, it elicits no information about capped versus uncapped claims. In doing the actuarials, they didn't differentiate between accidents that happen on the reservation or on the federal property versus other accidents. None of that was discussed. It's not in the application, the only document upon which ASIC relied. Same is true of the county's request. The county's request for coverage is contained in the application, and the application is devoid of any negotiations, any request, any mention of an attempt to get coverage limited to a lesser amount. ASIC, as the drafter of the policy, is responsible for its contents, but ASIC didn't include any limitations to coverage in the policy itself and didn't use the exclusion that it uses in other states. During the
So,
term
Ms.
of,
Sheehy,
yeah,
excuse me, can you address ASIC's contention and very heavy reliance on the coverage portion of the policy that says legally obligated to pay?
yes. First of all, I'd like to note that while ASIC raises that argument now, ASIC never reserved its rights to limit the county's coverage. Another inconsistent action on the behalf of ASIC. There is no reservation for ASIC to limit the coverage that it provided to this county. ASIC has relied on this legally obligated to pay language in its policy. Again, this is a scope of coverage provision, and we know that this claim did in fact fall within the scope of coverage. ASIC is trying to rewrite and tailor this to eliminate claims that are never mentioned, were never negotiated, and aren't part of the policy. Now, ASIC admits in its opening brief at page 12 that if the county legally must pay as damages an amount meeting or exceeding the policy limit, then ASIC is obligated to pay the full limit, unquote. There is a judgment in place for $11.6 million. A judgment is a legal obligation to pay. ASIC now tries to get out of that legal obligation because after the opening brief, the parties negotiated through the mediator a settlement. And as part of that settlement, the county withdrew its challenge to the judgment. And so did ASIC. ASIC, who had joined in the county's motion challenging the judgment as to form, withdrew its objection to the judgment. This court has often recognized that even a stipulated judgment is presumptively enforceable as a measure of damages. That's in Abbey Land at paragraph 34. So now ASIC is asking this court to rule on an issue not before the court, an issue ASIC and the county withdrew, and find that the judgment, pardon? Oh, I'm sorry, and find that the judgment is a nullity or is unenforceable. There is no authority for this. In its brief, ASIC claims that it's a nullity because there's a covenant not to execute. There is no citation for this. Also, this is a crafty argument, and frankly, it required a little sleight of hand. To argue this point, ASIC provided this court with 2 pages of a 3-page covenant not to execute. These were attached to ASIC's reply brief at 491, 492. But let's review the page that ASIC admitted from its argument and its filing. This is handout 2. On the second page, here's what the parties actually agreed. In making this covenant to Gallatin County, plaintiff does not waive, abrogate, or diminish his rights under the judgment with respect to any parties other than Gallatin County and Rick Blackwood. The parties to this litigation consent to the filing of this covenant. ASIC not only withdrew its appeal of the form of the judgment, ASIC consented to filing of the covenant. ASIC cites to no authority indicating that a covenant not to execute against a tortfeasor constitutes a nullification of the judgment. This court has often recognized the efficacy of these arrangements for settlement purposes. In fact, encourages them, as in Abbey Land versus Glacier. where this court stated an insured is justified in taking steps to limit personal liability, including accepting judgment and covenant not to execute. ASIC attempts to distinguish all of the cases allowing covenants not to execute and enforcing judgments even when those are in place by claiming those are all bad faith claims. Daniels, let's be very clear, is not seeking bad faith damages here. Daniels is seeking an adjudication, a declaration of the rights and obligations under a policy of insurance. This is a claim for a declaration, and the obligation to indemnify arises not from bad faith or misconduct. The obligation arises from the insurance contract, the legally obligated to pay language that ASIC has already admitted. If ASIC admits that if the county legally must pay as damages an amount meeting or exceeding the policy limit, then ASIC is obligated to pay the full limit. This court has recognizes two methods to attack a judgment. And that is if there is collusion or if the judgment is unreasonable. There can be no collusion when ASIC agreed to the entry of the covenant not to execute and withdrew its own challenge to the judgment itself.
So I was looking at your handout with the plaintiff's covenant. ASIC isn't mentioned and didn't sign it.
No, ASIC didn't sign it, but you will see that the signature.
Well, they didn't sign it. They didn't agree to that.
We were allowed to represent to the court as part of the settlement that the parties agreed to the covenant, consented to the covenants not to execute. And I think the mediator, supplemental report to the court would also indicate that. I'll have to check that though, Your Honor. But ASIC is posing no challenge to the judgment. The judgment can only be attacked based on unreasonableness or collusion. ASIC is asking you to simply ignore the judgment. An insurance company is not allowed to determine which judgments it will indemnify and which it won't. I'd also like to react to the state of play argument. You heard a lot about the state of play at the time of this settlement.
Well, let's go back to that question just once more. So you're not suggesting that ASIC has to pay 12 million, are you?
No, we are not, Your Honor. We are only seeking a declaration of rights. We are claiming that the policy requires ASIC to pay its policy limits when the county is legally obligated to pay damages. And here they are legally obligated to pay damages.
I understand that part. I'm just trying to get this argument you're making about ignoring the judgment, which frankly doesn't make sense to me.
Which part of it doesn't make sense?
That entire argument. I mean, they're appealing the judgment.
Well, let me back up a little bit, Your Honor, because the judgment is against the county. The judgment was not against ASIC.
Okay.
And so ASIC, the county withdrew its objection to the judgment. At the time that was in play during this settlement, we had moved, Daniels had moved to strike ASIC's challenge to the judgment because the judgment was not against ASIC and ASIC had not reserved that right before. So as part of the settlement, we withdrew our motion to strike.
Well, I don't think we're going to find a meeting of the minds here anyway. But
right.
Point is, the county waived.
Yes.
Okay.
And also, when looking at the various state of play, I think it's important that this court also look at what the county, what their positions were when represented by independent counsel. As part of the record below, we have the county's bad faith complaint. It's at docket 180, exhibit 2. In that complaint, the county alleges that ASIC controlled the defense, that ASIC threatened the county with the cooperation clause, and that ASIC refused the county's demands, that ASIC paid the policy limits of $6.5 million. So to just set the judgment aside because ASIC doesn't believe that the judgment is enforceable after the county has entered into the settlement agreement will ensure that this kind of thing happens more often, where an insurance policy, which is clearly in place and clearly provides coverage, is held up with years of litigation when ASIC could have simply filed a deck action and had this determined. So the timing of the settlement is unfortunate. The reason for the timing you can find at docket 180, exhibit 2.
So could I just ask a quick clarification, because just before, I mean, after I think we classified this, we got an agreement from ASIC to withdraw a certain argument in it from its opening brief that relates to the court's failure to conform the judgment to the cap. So does that weigh into the argument you're making here?
Yes, it does, Your Honor, because at the time that we settled, and you'll see it in the mediator's report, ASIC had agreed to withdraw that argument. And in preparing for the argument, we realized they never really did it. And so now ASIC has done what ASIC agreed to do many months ago as part of the settlement. It has withdrawn its argument that the judgment should be conformed to the policy limits.
So Ms. Sheehy, I guess I'll follow up on my question to Mr. Hobine, where I asked him whether you could waive by course of conduct. And do you think you can, and you have legal citation for that?
Yes, Your Honor, and I'm sorry I don't have it right off the top of my head. We cited 2 cases in our brief that allow for waiver by conduct. We don't think it's necessary here because the statute, when viewed in terms of the entire statutory scheme, clearly allows clearly provides that by providing excess insurance, then there is a waiver on the insurer's part, not on the county's part. I'd also like to talk a little bit, if I've answered your question, Justice.
Sure.
We did present that below, the idea that there was waiver by conduct, and the court didn't rely on that. But that is an issue that has not been decided or addressed by the district court and would need to be addressed at an evidentiary level if it were to become important.
Ms. Sheehy, excuse me a minute. This is a case that seems pretty simple, but it has a lot of nuances to it, and it's pretty easy to get wrapped around the axle when trying to figure this out. But so at the bottom line here, if you had gotten the declaratory judgment that you think you should have gotten based upon the arguments that you presented, then what's the effect of that? Then that ASIC is responsible to pay $6.5 million on this $12 million plus verdict. Do I understand that correctly?
You do, Your Honor. This is still only a declaratory judgment claim. It is a claim where Daniels asked this court to affirm the district court's entirely correct decision that ASIC is obligated to pay $6.5 million. There is no claim here for the entire judgment. The judgment is simply the measure of damages.
Thank you.
I think my time is almost up.
Got a minute and a half.
All right. I want to note the difference between immunities and caps. ASIC has been bouncing back and forth between immunities and caps, and it's not a valid comparison. Montana law enforces immunities in 2911, and it has caps in 29108. The legislature has answered the question of what is the effect of purchase of insurance on immunities in 29111 by saying the acquisition of insurance coverage, including self-insurance or group self-insurance by a governmental entity, does not waive the immunity provided by this section. The legislature provided a completely different answer when asked the question, what's the effect of the purchase of insurance on the caps? And that they answered that question to put the onus on the insurer, both by requiring compliance with the insurance code and by saying, if you provide coverage, it says there's excess coverage, that coverage is good unless otherwise indicated. I'd like to finish today before my time is up. I want to bring my focus back to Sarah Daniels, where it should be. Nobody disputes that Sarah Daniels' life was forever altered by the negligence of Gallatin County. ASIC can only avoid its contractual obligation to pay $6.5 million to cover the county's negligence if the legislature did not mean what it said when it authorized the county to procure excess coverage in section 2.9.211. If the county did not mean what it said when it requested coverage in the amount of 1.5 million with 5 million additional excess. If ASIC did not mean what it said when it wrote a policy with no limitation or differentiation between capped and uncapped claims. When Tyler Delaney and ASIC did not mean it when they certified to additional insureds that this policy provided 1.5 million in coverage and 5 million in excess. And most importantly, this court would have to hold that for the last 60 years, the insurance code has not meant what it says. It mandates that every policy, even the one policy issued by ASIC in Montana, must contain all policy terms. Daniels respectfully requests that this court affirm the decision of the district court.
Mr. Hobine, I'll give you a couple of minutes.
You're muted, sir.
Thank you, Your Honor, for that reminder, and I'll try not to abuse the court's courtesy here. Just a couple of quick points. All of the argument about premium and about illusory coverage, all of that, not briefed, not argued, not one scintilla of evidence offered by Daniels in this case with respect to any of those things. And number two, Daniels has no standing to raise those arguments at all. There's no assignment from the county to Daniels here. Daniels is a stranger to this contract. And on top of that, the testimony is absolutely undisputed. All of the county witnesses testified as to exactly what they applied for. They applied for coverage up to the caps and for excess coverage to cover those claims that weren't capped. And the testimony is undisputed by all of the county employees. There were a number of them. The finance director, the deputy county attorney, a whole host, their insurance broker. There was no daylight in the district court between Gallatin County and ASIC with respect to what the policy covered and with respect to the premiums that were charged. As respects a reservation of rights, again, no standing to raise that. There's no assignment here. Daniels is not the insured here. And finally, Your Honors, this is what the case boils down to. Daniels acknowledges that 29108 protects the county. Daniels acknowledged that in their amended complaint. The county can't be liable for more than $750,000. That's a core allegation of this amended complaint. There is no jeopardy to the county from that judgment because Daniels admits that in their amended complaint. Next, Daniels argues that the policy must be in writing and must contain all of the terms between the parties. It is in writing and it does contain all of those terms. And one of those terms, completely unamended, completely clear here, absolutely no waiver. One of those terms is the general insuring clause of the policy. All sums the insured legally must pay and not more. That is the brick wall against which Daniels' arguments crash into at every turn. They cannot get around that general insuring clause. All sums the insured legally must pay. There is no endorsement, no agreement, no waiver of those terms. In fact, the policy limits here are only apply to claims that the insured legally must pay. That's the whole point. The limits do not speak to coverage. Coverage is a term of the policy, and we know what it is, and there is nothing in the policy that changes it. And Daniels have offered nothing. And my final point is that Daniels has not cited to a single decision, not one from any state, supporting their arguments here, not one. Whereas ASIC has cited the court to 4 different decisions from 4 different states, finding exactly as ASIC is arguing here and supporting ASIC's argument. 4 different decisions reaching that conclusion.
Sir, excuse me, I don't understand the significance of that point. This case is about what our statutory language means as applied to the policy language here in the circumstances of this case. So the fact that they haven't cited any extra jurisdictional authority seems to me to be meaningless, and unless I'm missing something here.
Your Honor, I think it's more than meaningless to require a party to support their arguments with legal citation.
From another state about a statute in this state.
Here there is no legal citation, no support for Daniel's argument from any place, Your Honor. That's my point. Not in this state and not out of the state.
Thank you very much.
That wasn't your point, but I'll leave you alone.
Thank you very much to both counsel. Court will now take this matter under advisement, and we will issue an opinion in due course.
Thank you, Your Honors.